and purpose of the UNCITRAL. The United Nations Commission on International Trade Law, UNCITRAL, is the principal legal body within the United Nations system in the field of international trade law. It was established by the General Assembly in 1966 after recognizing that disparities between national laws governing international trade created obstacles to such trade, and considered that through the Commission, the United Nations could play a more active role in reducing or eliminating those obstacles. UNCITRAL's role is to modernize and harmonize the rule of international trade. UNCITRAL carries out its work at annual sessions held alternately 1 year in New York and 1 year in Vienna. Substantive preparatory work on items on UNCITRAL's work program is usually assigned to working group, which generally hold 1 or 2 sessions per year and submit a progress report to the commissions. There are currently 6 working groups. Group 1, Micro Enterprises and SMS. Group 2, Arbitration and Conciliation, Dispute Settlement. Group 3, Reform of the Investor States Dispute Settlement System. Group 4, Electronic Commerce. Group 5, Insolvency Regime. And Group 6, Security Interest. UNCITRAL formally adopt a report on the proceedings of the annual session for submissions to the General Assembly. In accordance with the resolution established UNCITRAL, the annual report is also sent to the Trade and Development Board of the United Nations Conference on Trade and Development for comment.
Why is it relevant? The MLEC was the first legislative text to adopt the fundamental principles of non-discrimination, technological neutrality, and functional equivalence that are widely regarded as the founding elements of modern electronic commerce law. The principle of non-discrimination ensures that a document will not be denied legal effect, validity of or enforceability solely on the grounds that it is in electronic format. The principle of technological neutrality mandates the adoption of provisions that are neutral with respect to technology used in light of the rapid technological advances. Neutral rules aim at accommodating any future development without further legislative work. The functional equivalence principle lays out criteria under which electronic communication might be considered equivalent to paper-based communication. In particular, it sets out the specific requirements that electronic communication need to meet in order to fulfill the same purpose and functions that certain notions in the traditional paper-based system, for example writing, original, signet, and record, seek the achieved key provisions. Besides formulating the legal notion for non-discrimination, technological neutrality, and functional equivalence, the MLEC establishes rules for the formation and validity of contracts concluded by electronic means, for the attribution of data meshes, for the acknowledgement for receipt, and for determining the time and place of dispatch and receipt of data meshes. It should be noted that certain provisions of the MLEC were named by the Electronic Communication Convention in light of recent electronic commerce practice. Moreover, Part 2 of the MLEC, dealing with electronic commerce in connection with carriage of goods, has been complemented by other legislative texts, including the United Nations Convention of Contracts for the International Carriage of Goods wholly or partly by sea, the Rotterdam Rules, and might be the object of the additional work of UNCITRAL in the future. Additional information: the model law is accompaniment by a gate for the enlightenment, which provides background and explanatory information to assist states in preparing the necessary legislative provisions and making other users for the mix.
UNCITRAL contribution to the achievement of the substantive development goals is carried out on several fronts and addresses a number of different and interrelated areas. And for us poverty. And for us poverty and poverty in all its force everywhere. Industry, innovation and infrastructure. Build resilient infrastructure, promote inclusive and sustainable industrialization and foster innovation. Decent work and economic growth. Promote sustained, inclusive and sustainable economic growth, full and productive employment, and decent work for all. Gender equality. Achieve gender equality and empower all women and girls. Quality education. Ensure inclusive and equality education and promoting living and learning opportunities.
According to the procedure stipulated by the legislation of the Republic of Colombia, the CISD was presented to the Constitutional Court after being approved as law of the country by the Congress for the CISD to be executable in Colombia. The Constitutional Court has to verify all the formalities were observed and confirm constitutionality of the CISD after examining the formal aspect of the adoption of the CISD by the national government and approval by the Congress. The Court observed that the necessary requirements were met. In the course of material revision of the CISD, the Court pointed out the importance of the provisions, the preamble that affirmed that the adoption of uniform rules